Wisconsin has such a rich history, it's incredible. We actually had the last commercial crop cultivated in Wisconsin in 1957. It was processed in 1958. That's really incredible, and it's unfortunate that it has taken so long to bring Wisconsin on the list for legalizing industrial hemp, but we've done that. And now Wisconsin, along with the other 34 states that have legalized industrial hemp, are giving their farmers the freedom to cultivate that they always had before. And it's only been these past 80 years of confusion that have created this dichotomy of where we're having to go back and change laws to allow you to cultivate a crop. But we're there, we're getting there. And you are very lucky to have Jennifer and DATCAP issuing these emergency rules and working to get the program up and running for you so quickly so that you were able to join the 19 states that were cultivating last year, which is really incredible. So as Jennifer mentioned also, that all the authority that has been granted within the state legislation has all come out of the federal farm bill. And in 2014, in the Agricultural Act, section 7606 clarified that industrial hemp may be cultivated in a state by a state Department of Agriculture or an institution of higher education in the state that has already legalized industrial hemp. And it's also important to note that in that Agricultural Act, that industrial hemp was defined distinct from the definition of marijuana in the Controlled Substances Act. So we have a clear definition for industrial hemp, clarifying that it is not marijuana, and we also have the authority to set up programs in the states. And so as long as you are compliant with your state program and working with your Department of Agriculture, you have authority under the Federal Farm Bill for your cultivation. What's very important is that you comply with your state program. Because if you're not complying with your state program, then you're also not complying with the Farm Bill, and then you do not have any federal protections. So as Jennifer said, there's these reporting requirements, other specific requirements that you have to meet. Make sure you're meeting them, because that is how you can ensure your federal compliance. And she also mentioned the appropriations provisions. So since 2015, Congress has gone on to protect the provisions that they put in the Federal Farm Bill by creating appropriations provisions that have limited funding to agencies to interfere with the transportation, processing, sale, and use of industrial hemp within or outside of a state. And that's compliant with their pilot program. So again, all of these protections that have been set up federally are all dependent on your compliance with your state program. So I can't iterate enough how important it is to follow those rules. So I encourage you to work with the department, especially when you guys start engaging with sales of your products. I would encourage reaching out to an attorney so you can clarify some of these legal gray areas that are out there. It's very clear what the law says, but different agencies such as the DEA they are given their agency deference and making their interpretations, but it is creating some legal gray areas. And that's something that I work every day to clear up, Sam works every day to clear up, and we're trying to bring you the opportunities available to have that full commercial cultivation.